Good evening, everyone. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. In tonight's event, you will have the opportunity to speak with a panel of attorneys to get insight and guidance on landlord, tenant, and real estate law. Before we begin, I would like to share a couple things about Zoom. Please keep in mind that everyone's videos besides our speakers will be turned off. You will be muted unless you're asking a question, and then you may unmute yourself. If you have a question and would like to speak, please use the raise your hand feature at the bottom of your screen in Zoom. If you click on reactions located at the bottom of the screen, it'll pop up for you. Also at the bottom of your screen, you'll see a chat feature. If you would like, feel free to go ahead and open that if you don't have it open already. I'll be using the chat to list by number and name whose turn it is next. Please respect others and wait to be called on. We want to avoid speaking out unless it is your turn. If you speak out of turn, you will be muted. Also at the bottom of your screen, because I saw someone turn it on earlier, we do have closed captioning. So if that's something that you would like to turn on, at the bottom of your screen in Zoom, there's going to be either a logo that says CC, or you might have to click the more button to see it, and captions will pop up and you can click on that, and we do have closed captioning today. For those of you who are calling in, if you want to speak, you can press the unmute button and we will see it and add your number to the list of who to call on next. So there is a way for us to see that you have a question as well. Once myself or the moderator calls on you, then you may speak. Another thing I would like to mention today is that during the event, there might be some resources that the attorneys share during the presentation. And so I will be sending you an email following the event with that information. So just know if they mention it during the event, I'm notating that so I can send you in a follow-up email after the event. Without further ado, I'd like to begin by introducing our first speaker, Desiree Sanchez. Thank you so much for joining us. I'm going to go ahead and spotlight your video and turn it over to you.
Okay, great. Good evening, everybody. My name is Desiree Sanchez of Sanchez Law Group. I am a member of the Orange County Bar Association. I'd like to thank you all for attending our Ask a Lawyer event sponsored by the Orange County Bar Association and the Orange County Clerk of Courts. Before we get started, allow me to give you a little background about the Orange County Bar Association. The association has been around for 85 years. In addition to serving the needs of our members, one of our goals has been to reach out into the community and provide services and programs that will benefit Central Floridians. Some of our programs include our members' pro bono work with the Legal Aid Society and the Orange County Bar Association. Also our lawyer referral and information service, our Law Week program for school children of Orange County, and our free citizen dispute and family law mediation program. The citizen dispute and family law mediations are facilitated by an impartial professional mediator who listens to both parties and encourages a resolution that is satisfactory to both parties. It's a free program for anyone residing in Orange County. Tonight's Ask a Lawyer event is just one of those programs, and we hope you feel free to ask any questions you have about landlord-tenant law and real estate. I will help guide you through some of the issues you want to know about. Today's event will be recorded and shared on the Orange County Bar Association's Facebook page. Please be sure to like the page if you're on Facebook. Right now, I'd like to introduce Ebony Wiggins, the Operations Team Coordinator of the Self-Help Center, to speak about the Orange County Self-Help Center.
Hi, everyone. My name is Ebony Wiggins, and I'm the Support Operations Coordinator with the Self-Help Center. And I want to share with you some services that we provide at the Self-Help Center. So give me a couple of seconds here to share my screen. So the Self-Help Center opened in 2015 to provide customers with limited legal guidance and low-cost attorney consultations. The Self-Help Center attorneys can assist with the following case types: family law case, family law, that's excluding injunctions, restraining orders. They can help with small claims and residential evictions. Our attorney consultations are virtual. And our appointments are available Monday, Tuesday, Wednesday, and Friday between the hours of 8 to 4. To speak with one of the attorneys, it's $1 a minute, and they're in 15-minute increments. You can book your appointment online or in person. However, if you book your appointment in person, we only accept cash inside the center. Once you book your appointment, you will receive a virtual attorney appointment link. Some other services that we provide in the Self-Help Center are form sales. So you can purchase like your forms for your dissolution of marriage cases, your eviction cases, your small claims cases, and we offer completion assistance services. We also provide notary services and copy services. We also provide legal literature for landlord tenant issues. And then we also have computers available for you to do any court-related research that you may need, or documents that you may need to print out and file in your case. We're located on the 3rd floor at the Orange County Courthouse. We're located on the 3rd floor, room 340. And if you have any questions for the Self-Help Center, you can go to myorangeclerk.com, click on the Self-Help Center tab, and click Contact Us. Or you can reach us directly at 407-836-6300. And I'll be here with you guys this evening if you have any questions about the services that we provide at the Self-Help Center.
All right. So we are going to, thank you, Ebony.
Oh, you're welcome.
At this time, we're going to open the floor for questions regarding landlord tenant law and real estate law.
And just a reminder to everyone, if you have a question, please feel free. You can use the raise your hand feature in Zoom under the reactions button, or you can add your question to the chat. All right, we'll start with Karen.
Good evening. Thank you for being here. I just have a quick question on a tenant who previously had said that she had an emotional caregiver dog, and pets under 25 pounds were allowed, but hers was 70. So it became an issue. That tenant has moved on, but it's always bothered me. But how does that work?
Right. So, and you're asking in terms of the emotional support, like in terms of the pounds, like how much they can weigh? Is that...
If there are, what are the parameters of somebody trying to get around? It became very obvious she was trying to get around the pet weight limit, and then kind of said, well, this is my more emotional support animal, and so you have to accept it. I'm like, not really. Right. So I just want to know where that is, if you will.
Yeah, sure. I mean, I actually don't know the weight, but obviously, as lawyers, we're not, we're trained to find that information versus always having the knowledge, right up front. But I do know with emotional support dogs that you're not even allowed to ask them for the documentation that supports the fact that they can have an emotional support dog. However, I think that when you're talking about weight, Karen, if you, if I look to the statute and see that, yes, you are right in terms of, that they can only have a certain weight, then that's an obvious no-no. And I think that at that time you can share with the tenant that if they do not remove the dog, that you can terminate their lease. So, but again, I'd have to look at the statute in terms of the actual weight allowed.
Thank you.
You're welcome.
All right, our next question is from the chat. So, received a court eviction in San Antonio without representation in 2022. Can this eviction be handled? Can this eviction be handled this legal issue in Orlando?
The answer would be no if the eviction pertains to a residency in the state of Texas, the answer would be no. Florida would not have jurisdiction.
All right, our next question is there such a thing as a transfer on death deed?
There is. So normally it's called a ladybird deed. And we are a big proponent of ladybird deeds because they avoid the need for probate. And ladybird deed, basically the person owns the property for life, and it gets transferred to whoever it is that they want to receive the property upon their death. You also have a life estate deed that prohibits a person from actually, has the same effect, but prohibits the person from actually transferring the property or selling the property without the remainder beneficiaries actually signing. So Ladybird deed the way Ladybird deed is set up is that you can always change it. You have control. You can sell the property, you can mortgage the property, lease the property, what have you. But with a life estate deed, the life estate tenant is restricted. They can live there for their life, and then it goes to their beneficiaries, and there is this tight restriction where they will need the beneficiaries, the remaindermen, to sign documents that allows them to sell and whatnot. So the quick answer is yes.
Thank you. Our next question is, when a lease is written for one tenant and they want to add their boyfriend but not on the lease, meaning just as a guest, what are their boyfriend's rights about staying in the home if they break up?
So, there's a difference between being a guest and then actually being a tenant. And so a guest is a short-term sort of situation. And so and I don't think that the statute's clear on how much time is considered short-term or how much time is considered a guest, but I would imagine it would be about a couple weeks. And again, I can't say for sure whether, I don't think that statute's clear on it. But if the boyfriend ends up extending their stay and actually lives there, for a longer period of time, then you would actually have to evict, or not even evict, but the landlord would have to do what's called an unlawful detainer, which basically requires the boyfriend to leave immediately if the landlord so desires. There's no landlord-tenant relationship with that boyfriend, so that's why an unlawful detainer is necessary. That's the actual claim that would need to be filed. An eviction really it relates to a landlord-tenant relationship, and so if you don't pay your rent, it's an eviction. If he overstays, it's an unlawful detainer.
Thank you. Our next question, how can I handle this court eviction done in San Antonio? Unfortunately, we can't do visual chat, but if you wanted to unmute yourself, you can.
Well, I think what they're asking is whether they can attend virtually, is what I think is being asked. And if, how do you handle it? You retain counsel in San Antonio, would be my suggestion. If the courts allow for like Zoom appearances, and it's a very small matter, maybe you can handle it, but I'm always a proponent of retaining counsel, because if they get an eviction against you, of course, they can then pursue any sort of money damages against you, and it can affect you getting garnished, and so you may want to simply retain counsel in San Antonio.
Thank you for clarifying that. Our next question is, what rights do you have to your unit over landlord rights to enter into the unit without your permission?
I think it depends on what the lease says. Normally a lease will say, reasonable notice, what is deemed reasonable notice to one person may be different from another, but reasonable notice generally is like 2 business days, 3 business days. You know, obviously a landlord has the right to enter if there is some sort of emergency. But I would refer to your lease to see what it says.
Thank you. Our next question is, in the case, about the boyfriend, can you file a trespassing against the boyfriend who overstays at the residence?
Yeah, I don't think so. If he like has his belongings there, you know, normally the police don't like to get involved in those sort of matters. If he can, you know, I mean, you can try. There are rare cases that the police will say, look, you gotta go. But there are other times where the police don't want to get involved and they'll say file a civil action. So you can definitely try.
All right, our next question is, what rights do you have on requesting new appliances over used ones?
Unless your lease states that they're required to put new appliances, you know, a landlord can have used appliances. What at the end of the day, what matters is do they work? They may not be as effective as, you know, new appliances, but do they work? Or is it reasonable? You know, does the dryer take 3 hours to dry my clothes? Then you know, you arguably you don't have a very a good appliance that you have an appliance that should be changed. But if you know, if the dryer takes an hour and 20 minutes instead of an hour, I don't think that you can make an argument that, you know, it's not a working appliance. So, but in a nutshell, if used appliances are allowed in a resident on the premise.
Thank you. The next question is, what rights do you have for testing for lead-based paint?
So again, I would, I mean, if there's lead-based paint, I believe that would be grounds for terminating your lease. So normally when you have, you know, when there's a situation with a landlord, such as lead-based, it could be mold, it could be a non-working air conditioner. You give your landlord 7 days to cure. You're required to give them at least 7 days to cure. If they don't cure, then you have couple options. You have the option to terminate, or you have the option to fix it and reduce your rent. But again, you have to formal notice them, giving them an opportunity to cure.
All right, our next question. I have been in my apartment for 2 years. In the lease, it came with a pool and cable. Now we have new management and the cable and pool have been out for nearly a month. What can I do about this issue?
Again, I would refer to the lease. Is a pool required? Was cable included in your lease? That's what matters. So those are kind of, you know, normal, you know, amenities that are extra that normally are not included in the lease as being required, that it comes with the premise. So that you may have an uphill battle if you are trying to terminate. But if the cable was included, you can say, okay, I'm paying $50 in cable, and so my rent should be decreased by $50 if in the lease it was supposed to come with the cable.
Thank you. Back to the San Antonio question. Statute of limitation issue was 2022 in San Antonio, ends when?
Yeah, I cannot answer that. I'm not barred in Texas. I'm not allowed to practice law in Texas.
Thank you. Our next question is, can management go into my apartment when I'm not there without warning?
Again, refer to your lease to ascertain whether or not it states that they are allowed or not. They should not, you know, normally a lease, again, just going back to what I shared earlier, normally in a lease it'll state that reasonable notice, with reasonable notice, they can enter into your apartment. So I would refer back to the lease on that.
Thank you. Our next question is, for Ladybird deeds, Would the process involve recording in public records? And will dock stamps need to be paid to change the current home's deed to a Ladybird deed?
Yeah, that's a good question. So, yes, recording is needed. And in terms of dock stamps, no, you should not have to pay dock stamps. Obviously, I would get with the county to confirm that. My clients tend to have me not pay the dock stamp, so I always let them know, hey, get with the county, because you're not transferring title. The person who owns it still owns the property. So I don't believe that dock stamps are required, but you can confirm.
All right, I just want to remind everyone too, if your question is being asked and you have a follow-up question, or if you'd like to unmute yourself to respond to the question, feel free to unmute yourself. We're still taking questions. And so if you want to raise your hand and unmute yourself, or if you want to add your question to the chat, please feel free to keep doing so. While we're waiting for another question, I'll go ahead and just mention again, this recording will be found on the Orange County Bar Association's Facebook page. So I'm going to go ahead and add that to the chat. After this event, I will be sharing all these details into a follow-up email to all attendees, and you'll be getting more resources that is shared by the Orange County Bar Association and the Clerk Self-Help Center. We will be continuing the Ask a Lawyer virtual events in 2024. So that is something to be on the lookout for.
One thing that I noticed, I'm not sure if I answered the question. It asked, what rights do you have for testing for lead-based paints? And I thought it was a different question. So one thing you may want to do is get with an environmental, I believe there's an environmental organization that can test for that if you think that there is an issue. Let me just see. Because there's supposed to be a lead-based disclosure that is provided to you in your lease. So that may be something to do a little bit of research on. I actually have never been posed that question, and no client has actually ever asked me that, but I know that that is something that, if there is a lead-based issue, that you can have EPA involved with that to get that tested. So that may be something to look into. Somebody asked a question, what is the best way to evict a person if they repeatedly violate the terms of the lease without spending a fortune on an attorney? Well, I mean, you have to follow statute. So, statute gives, just like a landlord has a certain amount of time to cure the tenant as well. And so if they are in violation of a lease, you can give them, you have to follow statute, giving them proper notice of the violation. And if they don't cure it, then you can, terminate the lease. If they repeatedly continue to violate, then I believe that it is grounds for termination, but you have to be careful, because if they do get an attorney, that, they can try to argue, but the idea is to have all your ducks in a row. So make sure that you're following statute, that you're telling them about the violation, to cure the violation, giving them, the specific time. I want to say 7 days as well on that. If they don't do it, you can terminate. If they can, if they do it for a brief period of time, you send them notice again. And I would say at least 3 times would be reasonable to give them that opportunity if they're continuing to do the same violation. I think that judges would agree that, hey, you shouldn't have to continue to put up with that as a landlord. it's not black and white. I just want to make sure you understand that there's no statute that says like you have to send formal note, as far as I'm concerned, as far as I understand, that there's no statute that says, okay, you got to give them 3 times, then you can terminate. But I think that it would be reasonable that you can make that argument, that they continue to violate.
Thank you. Our next question is, what is the level of responsibility does a landlord have to making sure the neighborhood is quiet and peaceful? Meaning if a new person moves in across the street and has loud parties, can the tenant break the lease?
So the landlord, of course, has the obligation for quiet enjoyment of the premise. And so if it is the landlord that is in violation, then, that is an issue. In terms of loud parties, it is your job as a tenant to go ahead and report them to the police for, nuisance, and, loud noises. The police will come and they will tell the people that they are to, decrease the noise. But it's not the landlord's responsibility. It is, again, going back to landlord's responsibility. Yes, they are required to have quiet. You have the right for quiet enjoyment of the property, but the landlord is not on the hook for someone else's violating, the law with being loud and causing a nuisance.
And just to confirm, the second part of that was, can the tenant break the lease for that reason?
I don't believe that a tenant can break the lease because of loud noise by a third party. I think if you have a situation where in the backyard, the landlord is working on a shed, building a shed, and that they have control over that and they are ruining your quiet enjoyment of the property, you have a case. You don't have a case if it's a third party that the landlord has no control over people who moved in and are messing with your quiet enjoyment, but you have a responsibility to report them if you want quiet enjoyment.
Thank you. Our next question is, what is the process for getting an eviction removed from your credit history?
I don't know that answer. I'm not certain if that's possible. I'm familiar with, criminal backgrounds getting that removed or whatnot, but no, I'm not familiar with evictions.
Thank you. For those of you who may have joined a little bit later, please feel free if you'd like to, if you have a question, you can unmute yourself at this time, or if you wanted to add your question to the chat. We're still taking questions. We still have about an hour left of the event. Unless we're out of questions. All right, so we got another question. Is it lawful to break a lease when the landlord has made you unsafe because of theft and assault?
I think I would need more information as to what the landlord did to make you unsafe.
Would you like to share more to the person who made the comment? We'll just wait a second to see if they type. We'll come back to that question just to see if they type up some more information, but we'll go on to the next question. What can you do to make a company leasing office resolve a wrongful eviction?
Again, May, I think I need more information. I don't know what they did wrong. So difficult for me to answer that.
And for those of you who are following up to these questions, feel free to unmute yourself if you would like to answer that verbally, or you can continue to write in the chat. It's up to you. All right, we'll move on to the next question. What are the most common issues you see in your office with regards to tenant concerns and landlords?
About landlords, tenants. That's a good question. And I don't know if there's one, I have to say most of the time it's landlords against tenants, but I had a recent case with a non-working air conditioner. So I was able to assist the client with the termination of their lease. Yeah, I think sometimes landlords can be bullies, so it's just important that you hold them to whatever the lease terms are. Just like, and I would even say, just like someone had the question like, hey, is my landlord allowed to enter the premises without my permission? Unless the lease says that, they should not be entering your place without permission. So I would definitely, would include that, but most of the time, what we're assisting with is landlords against tenants. So it's extremely rare where a tenant has a great case. I mean, I think self-help eviction where a landlord tries to change the locks and doesn't use the court system to evict is a problem. And not doing the eviction properly because they're required, they can't just file an eviction. They have to give proper notice first, whether it's terminating the lease after a lease has expired, making sure to give proper notice for the tenant to vacate. It could be the 3-day notice for non-payment of rent. It could be the fact that tenant allegedly violated the lease and the landlord moved forward with a civil action without properly noticing the tenant, allowing them to cure. So I would say those are the big ones. When people don't have an attorney, they think they know and they don't know what the proper procedure is.
Thank you. I'm gonna go back to one of the earlier questions from May. So two-part. Another renter lied on them, said they did something that they did not, like threatened them, and they were evicted. So what can you do to make a company leasing office resolve a wrongful eviction?
So another renter lied on them, said that they did something that they did not, like threaten them, and they were evicted. I mean, that is a he said, she said. So it's not just about overturning a wrongful or resolving a wrongful eviction. You would have to actually counterclaim. So if they move forward with an eviction, you have the right to counterclaim against the landlord for the wrongful eviction, so that that's your time to fight, your time to that's when you should have made that contrary argument. If you did not do that, it's definitely a harder fight, but you can go ahead and file a civil action against the landlord for the wrongful eviction so that you can actually have the eviction removed somehow from, because they did not have the legal right. But the problem with that is that, you have, unless your due process rights were violated, that was your time to fight and prevail over the eviction. So, I don't know what arguments you made during the eviction. I'm not sure if you responded at all. I'm not sure if you did a counterclaim, but that's your time. That's your time to go in front of the judge.
Thank you. Our next question is, what are the pros and cons for buying and selling real estate as is?
Well, so, I mean, 99.9% of the contracts out there are as-is contracts. So that's the normal standard Florida bar contract is as-is contract. So, if you're the seller, of course, that's what you want to do, is you want to sell as is. so that someone cannot come back and say that, you know, you didn't, that all these things are wrong. But I mean, normally in a real estate transaction, you know, even if you enter into an as-is contract, you have the ability to have an inspection. And, you know, during that inspection period, normally it's 10 to 15 days after entering into a contract. So, and if you don't like what you see with the inspection, that's your time to go back to the seller and ask for them to remedy certain things. And if they don't, that's when you terminate the contract if you don't want to move forward. So normally, you know, all contracts pretty much are as is contracts. So that's kind of the customary route that everybody goes.
Thank you. Our next question is, do real estate attorneys do closings for sale by owner? What is an average fee?
Yeah, so many, you know, it's more of a phenomena up north to have a real estate attorney. Down south, you're not required to, and so many people don't. But I'm always of the mindset people should have an attorney. But and especially with a for sale by owner, you don't have realtors involved, so it's advantageous. You know, I own a title company. I'm also a real estate lawyer, and so both of those mesh well with people for sale by owners who want to create a win-win for themselves. In terms of the average fee, it really depends. So if you know, my team actually handles the closing and I'm not involved, you know, it's the standard fee. It's pursuant to Florida law. There's really only like a couple of fees that the title company has I guess the ability to be flexible on, and that's the settlement fee and then like a wire fee, whatever their bank charges for a wire. Those are usually the two, and maybe even like overnight packages, like that fee. You know, one title company may have a relationship with a FedEx or a UPS that another one doesn't. But those are small. Really, it's the settlement fee. Generally will run between $350 to all the way to $900 on the settlement fee. You also have the title insurance fee, which is pursuant to Florida law. You have doc stamp fees, which is again pursuant to Florida law. You have to record the deed, which is pursuant to Florida law. So all of those are all regulated by the state. Really, it's the settlement fee that's the difference.
Thank you. Do we have any more questions? All right. So, according to the question earlier, I'm going back really quick. Earlier, the question was, is it lawful to break a lease when the landlord has made you feel unsafe because of theft and assault? And why I was made unsafe is landlord assaulted me because I left the refrigerator door partially open and assaulted while agreed packing up and stole 2 items. Landlord, therefore, breaking the lease would be reasonable, and landlord should return the rent money and deposit.
So, did you file criminal charges against your landlord? That's number one. So, I mean, a landlord would be, I would imagine, wouldn't want you there if there's a criminal charge pending against them. So, you know, they may be agreeable to a termination of the lease. Proving that 2 items were stolen, I think that's a long shot. And again, I'm very clear, you know, I've been practicing a long time. So people say, well, something was stolen, and unless you have witnesses to that, you're ready to, you know, spend the money on to prove that things were stolen. You know, it's just harder to prove, and it creates an issue for you, because if you end up with an eviction, that's not good either. So I'm very frank with people, make sure you have, you know, it's very black and white as to what's happened and, you know, because you have the assault, it's possible you can terminate the lease just based on that, because you can say that that landlord ruined your quiet enjoyment of the property. That is enough to break a lease. And yes, you can be returned the deposit, but however, I'm sure you know that it's not just a matter of fact that you get the deposit, you have to leave the property in broom-like condition, cannot be damaged. And normally you get the deposit and they're required to provide to file a claim on that deposit within a certain period of time. And if they don't do that, they have to give you your deposit.
I think in response to that question, the attendee wrote, after I left, received a 5-year injunction.
So it sounds like you already left. And also sounds like you're the one that got the injunction against the landlord. So, yeah, I mean, that's grounds for termination of a lease. I would imagine that you would prevail because I mean, again, just goes to, there's no more quiet enjoyment of the property. And a landlord is required, they're obligated to give you that.
All right, thank you. Our next question is, if you purchase property and then find out someone is squatting there, how can you get them out legally?
You filed an unlawful detainer action.
Thank you. Our next question, okay, so part of the question of the real estate attorneys doing closings, is the attorney fee part of the settlement fee?
The attorney fee is not part of a settlement fee, no.
Okay, thank you.
And
And
just
go ahead.
to kind of follow up on that, if like there's an hour's worth of, time that the seller wants to, consult with me as an attorney or maybe any other, I can only speak for me, but the idea is to help the seller through the transaction. And if they need hours of time, 1 hour of time, that's not a problem. It would just be kind of waived because they're doing business with the title company.
Thank you. Okay, I'm so sorry. We're gonna go back real quick. With the squatting, how can you get them out legally? What was the fellow lawful, what was the rest of that?
Unlawful detainer.
Unlawful detainer. All right, perfect. Is there something in Florida called a tenant at will if your guest has been staying there for 2 weeks and does not want to leave?
So there's a difference between a tenant at will and a guest, I believe. And again, I mean, I'd have to rekindle my memory on this, but my understanding with a tenant at will would be someone that, that no one's required. It's like an employee at will. It's like you're not required to stay there for years and years and years. So I don't know why those two sentences are together. So, because if a guest doesn't want to leave, that's a problem, of course, but you're going to do an unlawful detainer action against that person. Again, unlawful detainers are, why you do an unlawful detainer is because the landlord never gave permission for that person to reside there. And so they can immediately require them to vacate, and then file a action after that. I tell you, in this world right now, the rent is so much, people are desperate.
Thank you.
For staying. They're welcome.
Do we have any other additional questions? Again, if you want to unmute yourself or if you want to add it to the chat, we are still taking questions. Also wanted to mention that before you leave today's event, please make sure that you grab any links if you're interested in it, or any of the information that you have in the chat. You can make sure that you save anything that you're interested in, because once you leave the event, the chat will disappear, so you won't have access to that after you leave. So just wanted to make sure you guys know that. Again, all of the links or resources that were mentioned in today's event will be emailed to all the attendees after the event. As we're waiting for questions, I'll mention our next Ask a Lawyer virtual event will be in January. We're still working out on the details, but please feel free to continue to monitor the library's website and also the Orange County Bar Association's website, where we will update with that information. I'll also send an email out to all the attendees with our next event information once that is confirmed. And then while we're waiting for a question, there's one more thing I wanted to mention. We are having a landlord and tenant rental resources event provided by the Orange County Office on Tenant Services. So that event will be in December, just in case, because it's such a close topic to tonight's event. If you're interested in that event, that is in person at the downtown library, the Orlando Public Library. And so I'm dropping that information into the chat in case that is something that you're interested in as well. All right, we're gonna wait another minute or two. If anyone has any questions, again, feel free if you want to unmute yourself, or if you wanted to add anything into the chat. We're still taking questions. All right, so I'm just gonna do a couple announcements just to see if anyone has any questions while we're wrapping up. Okay, we got one in the chat. Do you have any opinions about working with Airbnb?
In what way?
Could you explain a little bit more for that question?
Sure. Can you hear me?
Yes.
Oh, about, renting out one of your rooms or a small house in the back. Have you had any issues come before you with, like,
With
does
Airbnb?
Airbnb usually take care of you, or is it a risky thing for, an individual homeowner to do? You know anything about that?
So I have not had anyone come to me with an issue with short-term rental, but I have, read up on it, about potential like issues that have arisen at times. Obviously, there's a lot of positive, but there's always negative, right? It's like riding with
Right.
Uber. We all know about incidences that have happened with Uber. But for the most part, it's it's a safe form of transportation. So same with Airbnb, there's an opportunity to make, good money from it, but you do have some people who will overstay their welcome. And getting them out, is likely going to require you to get a lawyer and get them for, get an eviction, and, there's possible money lost there. So I would just, my 2 cents about that is just be careful, read the reviews on the person. Families are always great. Like when you have, individuals, sometimes they're about to have a party and they're right. So you just want, I would just say, not, I wouldn't say not to do it. I would just say be careful.
Yeah. So overall, though, doesn't Airbnb protect you, like for getting people out, or you know anything about that, or?
I don't believe they do, but you may want to inquire with them about that.
Yeah, probably see what they have to say and then contact the lawyer if things weren't clear and they weren't forthcoming.
Right.
Because I wouldn't think that you should be stuck if someone has made a reservation to spend a couple nights, and then you go and they're still there the next morning. You can't just ask them to get out. Is there any kind of Florida law that would say, no, you can't just tell them to get
No.
out? I mean,
No,
it's not considered like hoteling or anything. Like, I don't know, what do hotels do? Do they just throw you out? Or
I
can you
mean, they
compare the
changed the
two?
key.
Yeah, so, all right, that would be something, that's good advice, and to really look into possibilities of what could go wrong before you might get involved. It's not just a simple thing. All right, well, I appreciate all your help tonight. Thanks very much.
Absolutely.
Bye-bye.
Bye-bye.
Thank you. Do we have anybody else who has any questions? We do still have about a little over 30 minutes left of the event, but if there are no other questions, we can end early. So just wanted to put that out there. If anybody has any questions and would like to unmute themselves, or if they want to ask any questions. Oh, I see another one. As a landlord, can you run a background check on a tenant before you give them the key?
Absolutely. You can run a criminal background, financial credit report background. Absolutely. In fact, I encourage it. And make them pay for it.
Thank you guys for your questions. You guys, I appreciate you guys sharing your questions, and thank you so much to Desiree for answering them, providing information, some
Absolutely.
helpful information. Thank you. All right, does anyone have any last minute questions? All right, I'm going to start wrapping up. So first of all, I just want to thank Orange County Bar Association, Candace, thank you, Desiree, for your time. Thank you to the Clerk of Court's office. Thank you so much, Ebony, for being here tonight. Thank you for sharing information. I do see another question. How can you get wages from a tenant that destroyed your property? Not wages, payment. How can you get payment from a tenant that destroyed your property?
Right, so, when you do an eviction, you can file a claim for possession as well as monetary damages. When you receive a money judgment, then you can start the garnishment process, which is a whole other process from the eviction. So that's, at the end of the day, most tenants, if they didn't pay, or they destroyed a property, they likely don't have money. And so, you can definitely try to garnish wages, but there's restrictions with how much you can get. It depends on salary and whatnot. So some of my landlords just ask for possession as a result. But obviously, if you have a destroyed property, I mean, you can definitely go after them, and I would even call the police as well, because at that point I think it's beyond a civil action if it's really bad. So I just want to share before we go that I want to thank all the attendees, with the event, and and please contact the Orange County Bar Association's Law Referral and Information Service, so that you can be referred to an attorney for a free consultation for up to 30 minutes. You also, you may be charged for speaking with the attorney or any services provided beyond the initial consultation. So be mindful of that. And again, my name is Desiree Sanchez of Sanchez Law Group, and we also, provide free consultation. So
Thank you so much, Desiree. This is going to conclude tonight's event. I put a bunch of links into the chat with some resources that were mentioned and some resources that are here for you guys. So I am going to be sending you an email after this event with that information. So don't worry about you don't have to copy everything right now, but feel free to click on any links that you're interested in right now. But thank you so much, Desiree, again, for your time, your expertise. Thank you, Candace, for helping to organize tonight's event. We appreciate it. And being able to bring this service to the community. Thank you to our attendees for attending and for asking your questions. We hope that this was very helpful for you guys. And that does conclude our event today.
Thank you.
All right. Thank you, everyone, so much. You
Everybody
have a
have a nice
wonderful
night.
evening.
Take care.
Thank you.
Thank you. Bye, Ebony.
Bye.